Court does call the case of the people versus Daniel Magoo. State your name.
Daniel Magoo.
All right. What are we doing on this today?
Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Go ahead.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement.
Buckle up, guys. Today we're going to dive into a tense courtroom showdown where the stakes are sky high. The judge calls the case, and the defendant steps forward, introducing himself as Danny Magoo. From the very first seconds, you feel the tension. This isn't just any routine hearing. Both the court and the defendant are visibly preparing for a battle over procedural and legal maneuvers. You can sense the weight of authority in the judge's tone and the defendant's cautious responses. This opening immediately sets the tone for conflict and suspense. Viewers can already feel that every word and gesture in this courtroom will matter. The stage is set for a legal drama that will unfold in multiple layers.
Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid on its face.
That were going to be addressed. That would be addressed at a preliminary examination, sir, as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion's denied.
Okay. Further, in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenged the prosecutor to prove all 3.
Sir, do
Yes,
you
sir.
wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed. A motion for all dismissal on all these charges.
They're not going to be dismissed.
No, okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point, but they're not going to be dismissed on an oral motion for this.
Here, the defendant challenges multiple charges, arguing that certain counts are invalid and questioning the legality of his detention. He carefully lays out his points regarding where he was held, attempting to sway the court. The judge listens carefully but firmly denies the early dismissal requests. The courtroom tension builds because we don't know how much weight the judge will give to his arguments. Every objection he makes seems to push the boundaries of procedural rules. You can feel the suspense as viewers wait to see if these arguments will actually make a difference. His legal reasoning and the judge's calm but firm responses create a chess match of courtroom strategy. It's a classic face-off between the defendant's challenges and the authority of the court.
Ms. Lumpy has let me know that all paper discovery has been sent to Mr. McGowan in jail. There are USB drives with video. A number of agencies were involved in the Michigan State Police case to respond to assist. I believe she has obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McGowan, and I expect those to be in the interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the video.
He has all paper discovery, but he does not have all video discovery. I expect that'll happen. So I'm not sure yet.
So, Mr. Magoo, are you going to have an objection to an adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, I would like a speedy trial. I would like to invoke my right to a speedy trial.
So you want your preliminary examination. Those are coming down to the jail to him.
I expect that you would have them early next week. So if the court follows its normal setting for preliminary examination, I would expect.
I would set it for the 19th and then.
In this segment, the discussion revolves around discovery materials and preparation for the preliminary examination. The defendant raises concerns about not having access to essential video evidence and other documentation. The court explains how these materials will be delivered to ensure fairness. Suspense comes from the uncertainty about whether he will be fully prepared for his defense. Each moment highlights how crucial access to evidence is in shaping the case outcome. Viewers can sense the pressure mounting as every delay could impact legal strategy. The exchange also subtly underscores the power dynamics between the court and the defendant. It's a moment where procedural details create real tension. You're left wondering if he will be ready for the next big courtroom confrontation.
Well, he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 5 different counts, pleading and eluding 4th degree, which is a felony punishable by up to 2 incarceration and $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200 nor more than $500 fine plus court costs. Count 4, operating while license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution, plus the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and/or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is fine plus court costs.
The judge methodically reviews all the charges, listing potential fines, jail time, and penalties. We get a clear picture of the severity of the alleged offenses, including both felonies and misdemeanors. This segment emphasizes how serious the situation is and why the courtroom atmosphere feels charged. The defendant's reactions show the growing realization of what he is facing. Each detailed count keeps viewers engaged, knowing the consequences could be substantial. The clarity of stakes adds suspense because it frames everything that follows. This is where viewers fully understand the battle lines: legal rules versus personal defense. The courtroom tension is palpable as both sides navigate the weight of law and evidence. The stage is now set for critical decisions ahead.
Mr. McGrew, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by
I've called the
Well, Mr.
prosecutor.
McGrew, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I've advised you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you. If that is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge. Torture, Officer, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
Tension peaks as the courtroom addresses whether the defendant will represent himself or seek counsel. The judge explains the dangers of self-representation, emphasizing the complexity of Michigan court procedures. After weighing options, the defendant requests legal assistance, signaling a turning point. This changes the courtroom dynamic and sets up the involvement of a public defender. Viewers feel suspense because this decision could drastically affect the strategy and outcome. The judge's firm guidance and the defendant's decision illustrate the high stakes. This moment blends procedural clarity with dramatic tension. Every word exchanged conveys the seriousness of legal choices. The courtroom drama intensifies as the case moves forward with professional representation now in play.
He's asked for examination in the case, and so I will set these for preliminary examination.
Okay.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay, or the prong test, is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting the release, Your Honor, PR bond.
And a response from the people regarding his bond.
People would ask the bond to continue, and he also, I'm sure, failed to appear before judge's place. So
Yes.
that warrant would also, with respect to the other, I'll wait. If there are pleadings filed by the public defender's office, will respond to that. And I guess my one remaining point would be, with the court's appointment to Eastern Public Defender's Office, I will make sure that the digital discovery that I referenced is served on the defender's office.
Now, the defendant raises serious due process concerns, referencing the 14th Amendment and procedural delays. He questions why certain actions took over 390 days, citing precedent cases to challenge fairness. Suspense is high because the audience watches whether these constitutional arguments could sway the court. The judge listens carefully, weighing the legitimacy of the claims while maintaining authority. Each argument adds tension, revealing a complex battle over not just facts but procedure. The stakes are immense. If validated, these arguments could impact the charges or timing of the trial. Viewers get a front row seat to a legal tug-of-war. The courtroom atmosphere becomes intense as every legal nuance is dissected. This is the kind of moment where procedural law meets high-stakes strategy.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied. So
That's what I
would
Mr. Choda said.
in any event, but also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in this bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And,
I understand the presumption of innocence.
well, and a lot of these are
April
facially
26th.
invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Or custody of.
I was dropped off at the hospital and they later tacked on
And
charges
you know
just
what?
like the fleeing and
evidence
eluding
will
charge.
Not meet that out, and that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
The courtroom reaches a pivotal moment when the defendant requests a bond reduction. The judge considers public safety, the risk of flight, and the severity of the alleged offenses. Tension rises as everyone waits for the decision, knowing it will affect the defendant's freedom in the interim. Ultimately, the motion is denied, leaving the defendant in custody. Viewers feel the suspense and frustration, as this decision underscores the seriousness of the case. The exchange highlights the balance between legal rights and community safety. It's a moment filled with authority, consequence, and unresolved questions. The courtroom drama peaks, showing the limits of procedural appeals in real time. This is where the stakes feel most immediate and real.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me.
Here, the judge sets the preliminary examination date for August 19th, 2025. This procedural step resolves one layer of suspense while introducing the anticipation of the next stage. Viewers now know exactly when the next courtroom drama will occur, but tension lingers because the outcome is still uncertain. The discussion clarifies logistics while subtly reinforcing the defendant's continued legal challenges. The courtroom maintains a serious, tense atmosphere as preparations move forward. Every statement reminds viewers that legal battles are ongoing and strategy will be critical. It's a calm but suspenseful interlude before more high-stakes action. The audience is left on edge, eager for the upcoming preliminary examination.
Including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. Complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that is attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there. They will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people of individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
Drama spikes again as it's revealed the defendant has filed civil claims against the court and other parties. The judge describes these as frivolous and a maneuver to manipulate the system. The tension here is not just about criminal charges, but a personal clash with authority. Viewers watch as the defendant pushes boundaries beyond the standard legal fight. The courtroom becomes a battleground of strategy, authority, and procedural control. This segment is captivating because it reveals the full scope of the defendant's audacious tactics. The audience feels the intensity and unpredictability of legal proceedings. Every statement contributes to suspense, showing that courtroom battles extend beyond just the facts of the case.
Even aware of such filings were being received by our office committee yesterday. At this point, we continue to proceed with this case, and a lot of time until I did otherwise from the elected prosecutor.
can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
Wish to raise change of venue, you may file that in writing, but to the extent you are